Supreme Court today. So the Supreme Court has 9 justices on it, and at the Supreme Court level, they are called justices, not judges. So there are 8 associate justices, and there is one Chief Justice. And so in this case, it is Chief Justice John Roberts as of right now. And both the Supreme Court, the associate justices, and the Chief Justice, they are appointed by the president, and then they are approved by the Senate. And this can sometimes be contentious. In the past, the last couple of Supreme Court justices, their appointments have sort of been controversial, just not necessarily controversial, but more like publicized than maybe in the past. So the last one we had Amy Coney Barrett, and that was with the death of Ruth Bader Ginsburg, and the one before that was Justice Kavanaugh, who was appointed by President Trump. And Kavanaugh went through his Senate confirmations, again, sort of rocky because of the sexual allegations that came out against him, sexual assault allegations that came out against him. And so he had to go through a Senate hearing to try to figure out if there was enough evidence to prove he was guilty. Is he of high standing to be a justice? And they ended up ruling that there wasn't enough evidence to actually prove anything, and so he ended up being approved by the Senate. And so you do have to be approved, even though the president appoints, and that is part of your checks and balances. So with the Chief Justice, they have a couple of different jobs and rules that they have to preside over. So first off, they are the head of the Supreme Court, and with being the head of the Supreme Court, that also makes them the head of the judicial branch of our government. Along with that, some of the things that they also have to do are things like presiding over the Senate trials if the president were to be impeached, and so he would preside over those trials. And then he also administers the oath of office to the president at the beginning of their terms. So with the Chief Justice and with the other 8 associate justices, some of the ways that you can get appointed, obviously, again, president appoints, Senate approves with a majority of vote. But unlike with the president, where there is a requirement in order to become president, the justices, there's really not many requirements. There's no age requirement. So where the president has to be a certain age, there's no age to be a justice. There's no requirement for where you have to live, and there's no citizenship requirements or any type of legal training required. So not necessarily like you don't have to be like a lawyer or have a law degree, even though almost every justice is going to have a law degree and serve as a judge before being appointed. But there is no like exact requirements for that, which is sort of interesting. So terms of judges, we've also talked about this at the constitutional level. So constitutional court, so again, this would be things like your Supreme Court, your district courts, your Court of Appeals. They serve for life or until they resign or potentially impeached from office. But again, that has not happened very often. Whereas your constitutional courts are for life, your special courts are for a maximum of 15 years. So that is a little different between constitutional and special courts. And here you have your judges' salaries. We've looked at this before, so I'm not going to spend a whole lot of time on it. But here are those salaries of those justices and judges. And that salary is set by Congress. So whereas the president appoints the justices and the Senate approves, Congress sets that pay, so that pay scale that you just saw. And some of the benefits of being a justice or judge is the retirement. So at the age of 70, if you retire with 10 years of service, you can receive a full salary for the rest of your life. Or if you retire at the age of 65 with 15 years of service, you can retire with your full salary for the rest of your life. So pretty nice there for retirement. One of the things when we look at the judicial branch and we look at the Supreme Court is judicial review. And that is something that you will need to know for your test. And in regards to that, like the judicial review we get from Marbury versus Madison, that's the connection you'll need to know for your test. So Marbury versus Madison was a court case in which a president was leaving office, and right before they left office, they appointed several judges into effect. However, the person who was supposed to hand deliver them never actually got around to it. And so when the new president comes in, they look in their desk drawer, and lo and behold, there they have all of those appointments. And so instead of handing those out to the people who were appointed by the previous president, they tear them up, throw them away, and they appoint new judges. And this does not make those other judges very happy. They wanted those positions, and so what's going to happen is that they're going to take them to court, and this is where the judicial review comes about. This idea that the Supreme Court can decide whether or not a law or an action is deemed constitutional or unconstitutional according to the Constitution. Because the Constitution is that supreme law of the land, they are sort of the person who decides whether or not are we actually carrying out, are we holding those laws up to constitutional standards. And so judicial review is that regulation that we get from Marbury versus Madison, and it's been used several times throughout the last years. Just to reiterate the jurisdiction of the Supreme Court, at the Supreme Court level, you have both appellate and original jurisdiction. So whereas at the district level, you have just original jurisdiction, and at the appellate level, you have just appellate jurisdiction, the Supreme Court has both types of jurisdiction, and you can see on the page in which they have those two types of jurisdiction. So appealing to the Supreme Court, we talked about how it is pretty hard to make it up to the Supreme Court. There's sort of a filter you have to go through. There's steps you have to go through. The Supreme Court, within a year, over 8,000 cases are tried to be appealed up to the Supreme Court level. However, the Supreme Court only has time to hear about 100 and 150 cases. They're only in office for a couple of months out of a year, and so they have to be pretty picky with what cases they decide on. And to do that, they decide they use the rule of four. So the rule of four is where four justices, they look over that information and they decide whether or not this is Supreme Court worthy. If 4 out of the 9 Supreme Court justices decide that it is in fact Supreme Court worthy, then it'll be sent up to the Supreme Court and the Supreme Court will hear it. But it has to be okayed by at least 4 of them. And some of the things that they'll take into account are things like the matter of it. They'll look at the lower courts and how the lower courts decided. They'll look at some of the records from the lower courts and what happened. And so there's a process even then of what goes on in order to make it up to the Supreme Court. This video you can watch in Schoology. It's a pretty good video to watch, but I'm not going to show it to you guys now. So when a Supreme Court reaches when a court reaches the Supreme Court, couple of things to keep in mind. So again, there's a filter that court cases have to go through. First, they go through the district courts, then they go to the Court of Appeals, and then potentially you can appeal it up to the Supreme Court level. However, there's a couple of different things that can happen. If you appeal it up to the Supreme Court level, the Supreme Court is going to look through all of that information, and they're going to decide whether or not they're going to okay it, or whether or not they're going to hear it. If the Supreme Court allows the lower court's ruling to stand, meaning they would have agreed with the lower courts anyways, and so why waste the time? So like allowing it to stand, then it just stops there. Like nothing's going to happen. That's the end of the line for that court case. However, the next step would be if the Supreme Court for some reason is looking through that information and they want more information, or they think the lower courts can still handle it, what they'll do is called remand. So the Supreme Court remands the case and they'll send it back down to the lower courts for reconsideration. And sometimes they'll give like feedback and suggestions for what to do, maybe point out certain parts in the Constitution or other cases that have happened before to help them decide on that court case. And so that is remanded. So when a case is returned to the lower court for reconsideration, or it could potentially go back or go up to the Supreme Court, the rule of four, people, for the justices say, yes, this is worth it. And so what will then happen is they'll send down a writ of cert. And so that writ of cert is an order by the Supreme Court directing the lower courts to send up the records. And so if the courts decide that they're going to hear it, they'll send out a writ of cert saying that, hey, we need all of your information, we need your records, please send them up so we can then look at this court case. And then the last vocab term in the Supreme Court is called certificate. And so this is used when a lower court is not quite clear about the procedure of a rule of law. And so they'll ask the Supreme Court, they'll ask maybe some of those justices for an opinion, for a suggestion, and then that's where it'll go from there. So that's a certificate. So when you look at how the Supreme Court operates,